Our four guests today, thank you so much. We are joined by this impressive group of legal scholars to talk about one of the Senate's most consequential constitutional duties, and that is to advise and consent in the appointment of nominees to the United States Supreme Court. As one of the three pillars of our government, we value the court's distinctive insulation from public opinion. The justices commit themselves to the law and to the constitutions, and what we're here to talk about today is what that Constitution says. I figure you guys can help us with that, and it's pretty plain language, as well as what history has shown us in terms of how these open vacancies have been handled in the past. We, of course, our thoughts and prayers are with the family of Justice Scalia and his friends and colleagues, one of whom, my former professor, so now I get to ask him questions, which I like, Geoff Stone from the University of Chicago, who worked with him as a fellow faculty member. So that's the first thing that's important to say. But the second thing is we now have a vacancy. And the Constitution is very clear where it says that the president shall nominate, and it also says that the Senate's role is to advise and consent. And when you look throughout history, you have to go back to the Civil War, to a time when a position was left open for over a year. You have to go back to a time before we had cars and before we had planes and before we had washing machines. We also look at the current justices on the court and the fact that since 1975, they're actually the average time from the time the person is nominated. We've been joined by a law professor herself, Senator Warren. We won't call her Professor Warren today, as well as Senator Cardin. You have to go back, when you go back to these nominees to 1975, it's taken an average of 67 days. I like to say 2 months, just 2 months to get this done. Yet some of our colleagues on the other side of the aisle are talking about holding this up for well over a year for 2 terms of the court, and we believe this is unprecedented and is against the clear words of the Constitution. So with that, we're going to, I know that we're going to be joined by some of my colleagues, but you know, since you're here, Senator Warren or Senator Cardin, if you want to say a few words, and then we'll hear from our witnesses.
Senator Klobuchar, first of all, thank you for doing this. We don't normally do this. This is pretty unusual to have this type of a forum. But what is happening here seems to me to be extremely disturbing and unusual. And I look forward to the observations of our panel. I regret I won't be able to stay for the entire presentations because I do have some conflicts that I have to do this afternoon, but I can assure you that we will be following your testimony. And I say that because our system of government depends upon the 3 branches of government, the respect for each branch of government, and carrying out our constitutional responsibilities to allow the system to work. And the president makes the appointments to the court, the Congress confirms or rejects those appointments, and the court is independent. That's the framework of our Constitution. It seems to me just incredible that we would think it to be okay or within the bounds of discretion for the Senate to say we're not going to take up a nominee that the president makes. So Madam Chair, I'm just interested in hearing from the panel, am I overreacting to this? Is this just business as usual in our political environment? Or is this something fundamental that really attacks the basic structure of our government and the respect for the 3 branches?
Okay, very good. Thank you very much. And we'll hear from Senator Warren, and then I appreciate Senator Franken and Senator Blumenthal coming, but I think then we'll hear from some of our witnesses and get to some questions. So,
I think Senator Blumenthal is sitting on the Republican side.
Yes.
I'm hoping it will wear off.
Yeah, exactly.
You know, I'm sorry.
You mean on them?
On them.
Okay.
Exactly.
That's all right. But there shouldn't be a Republican and Democratic side on this. You know, I want to thank you, Senator Klobuchar, for pulling this together. As Senator Cardin said, it's very unusual for us to do something like this. But it's powerfully important, and we'll be in and out because we've got other hearings this afternoon that were previously scheduled, but it's important to be here. You know, Senator McConnell was right when he said that the American people should have a voice in the selection of the next Supreme Court justice. And in fact, they did when President Obama won the election in 2012 by 5 million votes. Article 2, Section 2 of the Constitution says the President of the United States nominates justices to the Supreme Court with the advice and consent of the Senate. I cannot find the clause that says, except when there's a year left in the term of a Democratic president. Make no mistake, the Republican Senate's approach to this vacancy is completely unprecedented. The Senate has been holding hearings since 1916 on Supreme Court justices, and I just want to go over the numbers. 9 justices were confirmed within 11 days. No hearing at all, 9 justices. 1 justice withdrew before a hearing, and all others, every single Supreme Court nominee sent up by the president, every single one received a hearing in the United States Senate. Over the past 100 years, every single pending nominee to a vacant seat on the Supreme Court, every single one, has received a vote on the floor of the United States Senate. Now, for the rest of this year, President Obama is still President of the United States of America. Can I have an amen on that? If some senators don't like the person that President Obama nominates, then they can make their case to the American people and vote no. But it would be irresponsible for Senate Republicans to preemptively paralyze the nomination process that is laid out in the Constitution. Senate Republicans took an oath just like Senate Democrats did. Abandoning the duties they swore to uphold would threaten both the Constitution and democracy itself. It would also prove that all this Republican talk about loving the Constitution is just that, talk and nothing more. The president is currently reviewing candidates and making a decision about who to nominate. He is doing his job. And once he nominates someone, the Senate should do its job, the same job it has been doing for over a century, because that is what the American people sent us here to do. Thank you.
Good. Thank you so much, Senator Warren. We're going to hear first from Professor Stone, who I took 4 classes from, correct? So we'll hear from him, and then I know...
How good a student was she?
Good. That was a thumbs up in case the radio... Okay, and then I think we had planned to hear from Senator Schumer and Senator Durbin, so we're going to do that sort of intermittently, but let's start out here with Professor Stone.
Thank you, Senator. Thanks for inviting me here. In a recent piece in the Washington Post, Miguel Estrada and Benjamin Wittes proclaimed that the only rule that now governs the confirmation process for Supreme Court justices is, quote, the law of the jungle. There are no rules, end quote. This is profoundly misleading and dangerous. If taken seriously and acted upon, this misconception would undermine 225 years of well-settled tradition and throw the Supreme Court confirmation process into a state of partisan chaos that would damage both the rule of law and the Supreme Court as an institution. In fact, when we take a deep breath and actually examine the performance of the Senate over time, it's clear that the Senate defers to the President in these matters as long as the President puts forth nominees who are clearly qualified and who are reasonably moderate in their views. This has been the outcome in every single nomination in the last 60 years, and as far as I can discern, in virtually every nomination in American history. Moreover, this is true even when the Senate is controlled by the opposing party, even when the nominee's confirmation is likely to have a significant impact on the balance on the court, and even in the final year of a president's term. When all is said and done, nominees who are both qualified and moderate are confirmed, period. So what then are the rules or the traditions that govern Supreme Court confirmation processes? At the outset, it's worth noting that from 1790 to the present, the Senate has confirmed 91% of Supreme Court nominees that it has considered. And in the last 60 years, the Senate has confirmed 89% of the Supreme Court nominees that it has considered. So despite all the hand-wringing about a process without rules, there really has been no appreciable change over time. Now, of course, not every member of the Senate votes to confirm every nominee. So why do senators sometimes vote against confirmation? One factor, of course, is partisanship. Senators are more likely to vote to confirm nominations made by a president of their own party than nominations made by a president of the opposing party. But it's important to note that in the last 60 years, members of the Senate have voted 60% of the time to confirm nominations made by a president of the opposing party, and even when the opposing party controls the Senate has voted to confirm 80% of the president's Supreme Court nominations. Senators also take a nominee's qualifications into account. In the last 60 years, nominees who were perceived as highly qualified, such as Antonin Scalia and Ruth Bader Ginsburg, received an average of 97% of the votes, whereas nominees perceived as less qualified, such as Byron White and David Souter, received an average of 61% of the votes. Senators also take a nominee's judicial philosophy into account. In the last 60 years, nominees perceived as having moderate views, such as Sandra Day O'Connor and Stephen Breyer, received an average of 96% of the votes, whereas nominees perceived as having more strongly ideological views, whether on the right or on the left, such as Thurgood Marshall and William Rehnquist, receive an average of 77% of the vote. So what does this tell us? First and foremost, in the last 60 years, 19 of the 20 most moderate Supreme Court nominees have been confirmed by the Senate. This includes everyone from Sonia Sotomayor to Warren Burger and even Samuel Alito. The only exception was Clement Haynsworth, who was defeated because of allegations of financial impropriety. Even more impressive, even when the Senate was controlled by the opposing party, in the last 60 years, every one of the 8 nominees who was perceived to be both qualified and reasonably moderate was easily confirmed. This includes Charles Whitaker, Potter Stewart, Warren Burger, Harry Blackmun, Lewis Powell, John Paul Stevens, Anthony Kennedy, and David Souter. You might note, by the way, that every one of these 8 justices was nominated by a Republican president and confirmed by a Senate controlled by the Democrats. So despite all the fuss and fury over the Supreme Court confirmation process, the plain and simple fact is the Senate always defers to the president as long as the president puts forth nominees who are clearly qualified and who are reasonably moderate in their views. This approach has major benefits to the nation. It reduces potential fractiousness within the Senate. It minimizes the risk of confirmation stalemate. It reduces the risk of politicizing the judiciary, and it more or less averages out over time. In short, this is a sensible, pragmatic approach that has served our nation well. Although the Republicans' desire to obstruct is understandable as a matter of partisan self-interest, such obstruction would set a disastrous precedent for the future. If the president nominates a highly qualified and relatively moderate nominee, Senate Republicans should do their job, as members of the Senate have done throughout our history, and they should confirm that nominee. And let me offer a closing thought. The Republican members of the Senate Judiciary Committee announced yesterday that they will not consider any nominee put forth by our nation's duly elected president, no matter how qualified and no matter how moderate the candidate might be. This is unconscionable. If they carry through on this threat, it would be directly incompatible with their solemn responsibilities under the United States Constitution. It would be an action morally and legally on a par with the Southern Manifesto. If the Senate Republicans follow through on this threat, then from this day forward, Miguel Estrada and Benjamin Wittes will have been right. The Supreme Court confirmation process will be lawless. It will indeed be the law of the jungle. That is a legacy they will surely come to regret. Thank you.
Thank you very much. Professor Gerhardt from University of North Carolina in Chapel Hill, thank you for joining us.
Thank you very much, Senator. Thank you all for the opportunity to be here. It is always a great privilege for somebody who teaches about the Constitution and the legislative process to be able to talk to you about the United States Constitution. It is a special honor to appear here today along with my teacher and mentor, the former dean of my law school and my friend, Jeffrey Stone. You have my written statement, which I hope speaks for itself. In my oral remarks, I'll limit myself to 3 observations. To begin with, it is not a hard question to determine how and under what conditions the Constitution allocates power over Supreme Court appointments. The Constitution empowers the President to nominate and the Senate to give its advice and consent on nominations to the U.S. Supreme Court. The Constitution and the duties to nominate and consider Supreme Court nominations remain fully in effect at all times. The Constitution provides no exceptions, does not provide for its suspension or make exceptions depending on the timing of the nomination. The President and the Senate each retain its respective authority over Supreme Court appointments at all times, regardless of what is happening in the country, regardless of whether there's a civil war, a depressed economy, presidential election, or any other circumstance. Second, we have heard much about historical practices relating to Supreme Court nominations, though I think they are of limited relevance. To be sure, there is no tradition or precedent for the Senate to declare automatically that for almost a year it will not entertain or consider a presidential nomination to the United States Supreme Court. The so-called Thurman Rule is not a rule. It reflects how one senator felt at different times in his long career about what he thought the Senate should do in presidential election years if vacancies arose in the Supreme Court. But it is not a constitutional rule, and it has actually not been followed, ever followed, with respect to Supreme Court nominations made in election years. I can think of at least 13 confirmations which occurred in election years involving the Supreme Court, 3 of which involved Chief Justice nominations. I might even point out that today is the anniversary of Marbury versus Madison, opinion written by Chief Justice John Marshall, who was appointed by a lame duck president. Perhaps the most important thing to remember about historical practices, however, is they do not bind this institution. They do not rob you of your discretion or authority. They are not part of your oath. They are merely suggestions of how to use your power. They do not direct or mandate how you should use your power. What then should guide you and your colleagues? My own belief, based on a lifetime of studying this institution and the Constitution, is that you should consider what kind of precedent you're establishing. The choice to shut down the Senate nomination process, or the Supreme Court appointment process as well, for nearly a year is not grounded in some grand principle. Without any tradition to support such a decision, we know what guides it. Raw partisanship, the coarsest possible basis for a governmental action. We are told that the Senate will leave the issue to the next election. But what about our past several elections? Do they not still have effect? Didn't they give us a president and a presumably working Senate? Are those elections now null and void? The answer is obvious. They're responsible for the leaders we have now, and we do not expect those leaders to stop governing simply because it is an election year. Allow me to put my last point differently. For more than 25 years, I've studied the Constitution and particularly the Senate. I've had the honor of helping to finish the most recent edition of a legislative process casebook, which I co-edited with Judge Abner Mikva and Dean Eric Lane. What is the lesson the choice of not to govern will teach my students? What should they take away from all this? They will find no grand or noble principle at work here, for there is none. The Constitution does not cease to take effect during Civil War or even during World Wars. It was not suspended during our Great Depressions. Through all those times and more, Supreme Court appointments have been made, in spite of how turbulent they may have been. The Constitution recognizes no off-season, no timeout, no suspension for any reason. If our leaders could lead, and they did, during more turbulent times than these, then they can rise to the occasion now. The Senate's job is, and always has been, to govern.
Very good. Thank you so much. And we've been joined, by the way, by Senator Menendez of New Jersey, Senator Mazie Hirono of Hawaii, and Senator Schatz from Hawaii as well. So thank you. Next, Jamal, Senator Schumer, I think before he had to leave, was going to say a few words. Okay, well, we still... Okay, good, because you're from New York, so he is deferring to you, or at least you teach in New York. So Jamal Greene is, we welcome you. He is the Vice Dean for Intellectual Life and Professor of Law at Columbia Law School. I think we need a Vice Dean of Intellectual Life around here. That's why I included that title. But thank you so much, Professor Greene. Thank you.
Well, just let me know if you need me to step in. Thank you for the invitation. I want to make just 3 general points. First, about the lack of historical precedent for the Senate's refusing to consider a nominee for a Supreme Court vacancy. Second, about the consequences of inaction on a nominee during this presidency. And third, about the nature of the Senate's constitutional duty to hold hearings on a nominee to fill a vacancy on the Supreme Court. In brief, the Senate's outright refusal to consider a nominee to fill a Supreme Court vacancy is unprecedented in the modern history of this country. and threatens to create historic levels of legal uncertainty throughout the country. First, the historical precedent. In the last 135 years, dating back to 1881, no president has been refused to vote on a nominee for an open seat on the court. Over that time span, 7 justices have been nominated and confirmed during presidential election years, and 1 was even nominated and confirmed in the period between the election and the inauguration of a new president. You've heard a lot of talk about the failed 1968 nomination of Abe Fortas for Chief Justice and Homer Thornberry for Associate Justice. 2 points bear mention. First, unlike the situation we have now, there was no vacancy on the court at the time. Chief Justice Warren's resignation was not to be made effective until his successor was qualified. Second, the Senate did hold 7 days of hearings on the Fortas nomination, and it was debated on its merits during the summer before the election. That episode is not a precedent for failure even to hold a hearing for a vacancy that arises 9 months before the election. When we go back to 1881 and earlier, we see an additional pattern worth mention. In cases involving vacancies on the court, the Senate has never refused to act on a Supreme Court nominee put forward by a popularly elected president. 5 presidents have put forward Supreme Court nominees to vacant seats that failed to receive action in the Senate. John Quincy Adams, John Tyler, Millard Fillmore, Andrew Johnson, and Rutherford B. Hayes. None of these 5 men was popularly elected as president. When the people have spoken, the Senate has always listened when it comes to filling open Supreme Court seats. Second point, what are the consequences of inaction? One of the core functions of the court is to resolve divisions of authority among lower courts, and therefore to bring uniformity to federal law across the land. Leaving an 8-person court for an extended period of time severely undermines that function. Lower courts, governmental actors, corporations, and private individuals look to the court for guidance about what the law is. There's a substantial likelihood of 4-4 votes in closely contested cases on an 8-member court. A 4-4 vote affirms the decision of the lower court, but does not set precedent for the rest of the country. Moreover, the prospect of a 4-4 division might well affect the court's decision whether to grant certiorari in the first place, thereby leaving significant conflicts among the lower courts unresolved. This uncertainty will likely last for a long time. Based on the lengths of recent confirmation hearings, we should not expect the nominee of a new president to be seated on the court in time to participate in the 2016-17 term of the court. He or she would not hear his or her first cases until October 2017, 20 months after Justice Scalia's death. A final point. Does the Senate have a constitutional duty? I believe it does. The duty of a governmental actor is to exercise its constitutional power to achieve the Constitution's purposes. The preamble tells us that one of those purposes is, quote, to establish justice. A lengthy vacancy on the Supreme Court undermines that purpose. The Supreme Court is the only body subject to executive appointment that the Constitution provides for directly, reflecting the framers' deep concern over the lack of a federal judiciary under the Articles of Confederation. Whatever one thinks of leaving other executive appointments vacant, the Constitution treats the Supreme Court differently. When we are unsure what the Constitution requires, we look to establish conventions. As Justice Scalia once said, quote, where a governmental practice has been open, widespread, and unchallenged since the early days of the Republic, the practice should guide our interpretation of an ambiguous constitutional provision. In light of the long-standing tradition of giving due consideration to the President's nominees to fill vacancies to the Supreme Court, the Senate's constitutional responsibility here is clear. Thank you.
Thank you very much, Professor Greene. We've also been joined by Senator Merkley of Oregon and Senator Cantwell of Washington State. Professor Edelman.
I'm very glad to be here. Thank you so much.
And I should mention, you are a distinguished professor with Georgetown.
Oh, thank you.
You had the least amount of distance to cover, so thank you.
And I traveled the shortest way to come here today. But it's wonderful to see the Senate and that you have that you're doing this afternoon. I want to talk about this unprecedented development in a kind of a structural framework of the Constitution. This event that dramatizes as much as any event over the past 8 years how basically the party of no is undermining the very structure of our democracy. The proper functioning of the separation of powers between the President and Congress has been deeply damaged in a two-dimensional way caused by the Congressional Republican Party's disrespect for democracy and its reflective negativity about legislation. This has gone on from the moment of President Obama's inauguration and has contributed significantly to the current public disgust about the functioning of our government. Now, for the first time in history, we have a three-way breakdown in the separation of powers. This is a structural problem, and it is a constitutional problem in a structural sense. The nomination and confirmation of a Supreme Court justice is one of the most important responsibilities the other two branches have in our constitutional structure. For one of the major parties in our country to thumb its nose at that responsibility is to strike a blow at the heart of the idea of checks and balances that is absolutely basic to our constitutional framework. Suppose a state refused to have a structure of public education. Suppose a city refused to have a police department. We believe it's fundamental to our democracy to have a school system and a police department. Probably not the kind of dispute a court would take on, but we nonetheless think of it as an affirmative duty, a duty that is crucial in our constitutional framework. Here, the affirmative obligation is explicit. The responsibility to advise and consent is actually written in the Constitution. As Senator Warren said earlier and Professor Gerhardt, there is no exception for election years. When a seat on the Supreme Court is the subject, it is a responsibility that is at the very core of our constitutional framework. It is at the peak of importance to the functioning of our democracy. This basic duty has always been carried out by tacit acceptance and agreement without any question. There have been 24 instances in which a president has nominated a Supreme Court justice in the last year of the term. It has been the understanding of both parties throughout our history. The Republican Party is on a path to violate that tacit agreement. The Republican senators and others of their party are on the way to violating a fundamental tenet of our constitutional architecture. We've been watching a serious undermining of our democratic institutions for the last 8 years, and it's on the way to happening again. The Republicans have taken a dangerous step toward an unprecedented violation of the separation of powers if they continue to refuse to take even the tiniest step toward carrying out their constitutionally required responsibility of advise and consent. The death of Justice Scalia has unexpectedly brought the Supreme Court into the presidential campaign, which I believe is a constructive event for the nation. A debate about the role and direction of the work of the court, a debate about the very meaning of the Constitution, should be undertaken in a manner of dignity and respect. The reaction of the Republican Party up to now takes us in the opposite direction. Thank you.
Thank you very much. Senator Schumer, I'm going to say a few words.
I'd like to ask them a few questions.
Of course, yes.
Thank you. Thank you very much for your testimony. First question I have, you're all scholars who have studied the Supreme Court for a long time. Have you ever has there been at any other time in the nation's history something as damaging to the future of the court, the balance of powers, the structure of this country, as it relates to the Supreme Court than what is happening now?
I would say not. I mean, perhaps Roosevelt's court packing plan raised some serious issues, but I think this is even more defiant of the Constitution than that was. I think this is unprecedented.
Anyone else? Professor Gerhardt, Professor Greene?
Well, we've certainly had some unfortunate moments in our history. It's hard to say what the worst one is. But that
Well, is this way up there?
But this, I was about to say, that tells you something about the territory we're in right now. We're not looking at grand moments in the history of constitutional law. We're looking at low moments, if I may use that phrase. There certainly occurred previous in our history, but I think the very deliberate choice not to do something is itself unprecedented. And that's pretty remarkable in itself, because even in our past, when things have gotten bad, There's only been one other time when a group of people absented themselves, voluntarily abandoned being represented in Congress, and that was during the Civil War. And this is not the Civil War. Even then, though, the Constitution remained in effect, and I think it still remains in effect.
The only thing I would add is what's one of the things that's very worrisome about this is as Professor Gerhardt said, the precedent that it sets. This has crossed a line that is going to be very hard to walk back in the future. It's one thing to, obviously, politics plays a role anytime there's a nomination to the court, and people say things that they may not have wanted may not have said, for the other side, and that happens. That's just politics. But this is really something that's very hard to backtrack on. And if you say 1 year is not enough time, why not 2 years? Why not 3 years? Why not abdicate your responsibility? Why not just say, we don't agree with this president's policy, so we're not going to approve any nominations? I mean, this is just, I think, crosses a line that hasn't really been crossed yet.
And I imagine it could extend down to the circuit courts pretty easily as well.
Yes.
And I would just add, Senator, as I said in my statement, that there's just a different context as well as everything that's been said, which is the context of the behavior of the Republican Party over the last 8 years. This is really hitting a new low.
Right. And let me ask you this question, since right now, and if the Republicans get their way, I don't think it'll happen. I think there'll be enough public pressure on them and enough pressure in terms of what the Constitution says. Average Americans don't like what's happening here. They would sum up simply their view, do your job, not being quite as erudite as your statements are, but right to the point. But let's say, unfortunately, we don't get a new justice this year. As I said, I think they're going to have to back off as they backed off on so many other issues where the hard right has sort of controlled them. Tell us a little bit about the gridlock that would result, not just in the Supreme Court, but in the lower courts, and how it affects commerce and civil rights and all the other issues that the Supreme Court has as its domain. And that's my last question, so you can take some time answering it, or 1 minute and 11 seconds.
Okay. Well, I think Professor Greene did a very good job of talking about that in his statement, and so I don't want to preempt him here, but I think that it certainly produces a circumstance that in which the court itself becomes paralyzed and thus incapable of providing the leadership it has to provide to make the federal court system work.
Just go ahead, Professor Greene.
In this term alone, there are cases involving religious freedom, free speech, voting rights, executive power, abortion rights, labor rights, and any number of cases that don't get media attention. Right? The court has a docket of 70 or 80 cases a year. Virtually every one of those cases is a cases in which there's a division of authority among lower courts. That kind of uncertainty means that the law is different in some parts of the country than it is in other parts of the country. Unlike lower courts, right, the core function of the Supreme Court is to resolve those kinds of divisions. So leaving the potential for a 4-4 vote on the court hanging over the court for potentially 2 terms means that it really can't do its job in a way that not having a single judge on a lower court might be different.
And this is my last question, might this even have effect on jobs and growth, that companies and economic interests that are waiting for a decision and don't get them hold up in terms of, they hold up and they don't do the kinds of things they might have done to move forward in terms of creating jobs, for instance. There are probably lots of issues that various companies and groups are interested in that we don't even, we haven't even heard about.
Sure. We talk about investment-backed expectations, right? And
yes.
If you don't know what the law is throughout the entire country, it's hard to make sound decisions about how to move your business. So
it's possible this decision could hurt us in terms of job creation and job growth. Possible.
Certainly.
Okay, thank you very much, Senator Schumer. I want to mention we've been joined by Senator Murphy of Connecticut, way down there, and then also Senator Stabenow of the great state of Michigan. I'm just going to ask two questions here, and then I want to move on to my colleague, Senator Franken, and we're going to stay in the order that we came here. But this is a question about shall meaning shall. And so the Constitution says that the President shall nominate and by and with the advice and consent of the Senate shall appoint, a few others, judges of the Supreme Court. It seems to me that when you see the word shall in other parts of the Constitution, in Article 2, Section 2 says the President shall be Commander-in-Chief. That's pretty clear. I think we know that. It says, the 20th Amendment says the terms of the President and Vice President shall end at noon on the 20th day of January. These are just some examples of this. So if you could just comment about whether or not you think this language is clear. This would be called a softball question, but whether or not you think this language is clear, because to me it seems clear, but yeah, you guys are the experts, so.
Well, I was speaking to that, Senator, and so yes, is my answer. But I would go on to say that you have to, you could, as an underlining, as an exclamation point, this particular example of advice and consent, to which the word shall is used, is the most paramount, the absolute zenith of the application of it. So it's not only a duty, in all years, not with some exception for election years, but it's in relation to the whole fundamental structure. You've heard, and we all know about the implications if it stays 4-4 for a period of time, and the implications as a precedent for the future. But just to give the emphatic yes to your question, because the duty could not be more important in this instance.
If I can add words to
Professor
that.
Stone.
I have no doubt that if Justice Scalia, who is a textualist, was asked this question, and it was behind a screen, so he didn't know whether it was Republicans or Democrats who were on either side, I am 100% certain that he would say shall means shall in this context, and he'd be right.
Okay, very good.
If I may just add one more thing. I actually think the word shall takes on even greater importance over time. Because as the country itself has grown and the government has grown, it takes on an increased importance in ensuring that the government is functional. We want a fully functional Supreme Court, and by ignoring the actual meaning of the word shall, we're making the Supreme Court ineffective.
Just one question on one issue. For death penalty cases that come before the court, the last review, what's going to happen to those when it's 4-4? Is it the same?
There's a thing that happens, but but it, as was said here, it turns out that if whichever way it ends up, either that the court can't come to a decision it's 4-4, say it's divided in that way, it could be 5-3, but there will be a lot of times when it's 4-4. So it leaves the country, if you have different decisions in different circuits, you have a different law in different parts of the country.
On an individual death penalty appeal?
Well, yes, insofar as whatever the decision is where there's a difference of opinion among the circuits, it leaves that conflict in place and it doesn't resolve it. That's certainly one of the results of it. I mean, there is a result. It's the if the court is deadlocked, then the lower court stays as the law, which in terms of the question that Senator Schumer asked, there are going to be a lot of times where people who are major stakeholders in the economy and in the public sector want a full decision.
Okay, thanks. Anyone else? All right, Senator Franken.
Well, I agree with Professor Gerhardt and others who are saying this, I think, presents a dangerous precedent because what happens next time, is it 11 months or is it 12 months or is it 13 months or is it within 6 months of 11 months? And obviously, there's nothing in the Constitution that says anything other than it's the president's job. This is his job. Our job is to provide advice and consent. Seems pretty clear-cut. And also, I mean, scientists tell us that the president's going to be president for almost 11 more months. And it seems arbitrary. Anything seems arbitrary other than what's in the Constitution. You know, it's sort of ironic. You know, obviously our hearts go out to Justice Scalia's family, and Justice Scalia, I may not have agreed with him on a lot of stuff we didn't agree on. I thought he was very funny, if that means anything. But he was so devoted to the Constitution and was devoted to the actual text of the Constitution. The text seems very clear here. So let me ask you this question. If the majority leader wanted to change the Constitution to say that the president can't nominate a Supreme Court justice in, say, I mean, I think 11 months would be weird, but maybe he could make it a year, or if he wanted to, 11 months. What would he have to do? He'd have to get both houses and then 3/5 of the state, right? 3/4 of both houses and then 3/5 of the state. Now, could he do that now? I mean, could he try to do it? Would that be the constitutional way of approaching this?
That would be the constitutional way of approaching it, yes.
Okay, so he does have that. Okay, well, I just want everyone to understand that he does have a constitutional way to approach this, and I would suggest that he try it.
Yes, sir. That would be the way to do it. I mean, the fact is, the Constitution, I don't think, gives the Senate the opportunity to not govern. In other words, just to say, we're not going to do our job. I don't think that's an option.
No, I don't think it does now, but if he could amend it to say that we don't do
If it
our
got
job
amended in that
for a
way, then we would
period.
follow it.
And is it consistent to say that senators in the 6th year of their term probably shouldn't maybe be chairman of a committee?
Or shouldn't be allowed to vote on Supreme Court nominees.
Or shouldn't be able to vote on a Supreme Court nomination. That seems more consistent with what the majority leader is saying than a lot of what he's saying.
Right. All I can say is that would be a
makes
level
sense,
of
yeah, I
minutia that constitutional amendments don't typically address, but if it were properly done, then that would be the constitutional law.
Okay, good, thank you. I wanted to know that, thank you, my senior senator.
Thank you very much, Senator Franken. Senator Blumenthal from Connecticut, and himself a former Attorney General.
Thank you. Thank you to Senator Klobuchar for convening this gathering, and thank you to each of you for being here. First of all, very happy that we are the ones asking the questions and we're not in your class subject to the Socratic method. And I want to thank each of you not only for your scholarship, but also for your public service in various other capacities, and ask a question that I think reflects the work of the court that's often unappreciated, because the court, in almost all of its cases, makes decisions about what cases to take. Not just how it decides, but what cases to take, which usually, I think if the rules are still the same as when I was a law clerk, they require 4 votes. So an 8-member court also can change the agenda of the court by refusing to take even those cases where there are conflicts in the circuit, let alone put aside the decisions that may be gridlocked. The very agenda and docket of the court will be changed. Maybe one or more of you can speak to that issue.
Sure. As it stands with a 9-member court, you could have, if you have 5 members of the court who want to hear a case, who don't want to hear a case, I'm sorry, that's not enough because of the rule of 4 that you mentioned, Senator. But with a court of 8, 5 members of the court can prevent a decision from being, from a case from being heard by the court. And so not only do you have the prospect of the cases where the court actually takes being divided 4-4, but you have the prospect of cases that the court would have taken if it were at full strength not being taken at all, which is just essentially doubles down on the legal uncertainty that this refusal causes.
And the one thing, among other important tasks, one of the things that the court does is provide some certainty and resolution so that people can plan their businesses and their lives, whether they like the decision or not. Going to Senator Schumer's point, the lack of certainty impedes the ability to plan, to count on certain rights. I think that's one of the reasons why the founders created a court with the independence and impartiality that it is supposed to have. And I think what we're seeing is the threat of the kind of gridlock in the court that the American people find so abhorrent in Washington, D.C. these days. And what this obstructionism is doing, in effect, is to epitomize that partisan morass that people have come to detest, and dragging the court down into it and damaging the court itself, because at the end of the day, as we all know, the court has no armies, it has no police force. It depends on its credibility. Some have said it's a mystique, but it's still trust, faith, credibility of the American people. And if the people of the United States continue to see the court as simply another bunch of politicians, it will be diminished and ultimately damaged. So thank you.
Thank you very much, Senator Hirono, who was serving on the Judiciary Committee for a number of years. We miss her.
I miss it.
And she's now on the Intelligence Committee, but we hope she comes back at some point. We've also been joined by Senator Casey of Pennsylvania.
Thank you very much for all of you being here, and you've all made it very clear that in this instance, shall means shall in terms of the responsibility of the president and responsibility of the Senate. I was trying to think of what would be possibly an outrageous kind of an analogous situation. Maybe one would be that if the Senate were to tell a state who had a vacancy, a Senate vacancy, that you can't fill your vacancy for over a year. Too bad. I think that would raise a huge outcry in that state and any other state. I'm just wondering, are the Republicans violating the Constitution? Let's say that they don't change their mind, they're going to stick with their position. Are they violating the Constitution?
I would say they're violating the Constitution if they behave in the way they've now said they will behave. I think they have a
let's assume they're not
responsibility.
going to change their mind.
Yes, I think they have a fundamental responsibility, both based on the text and based on our 225 years of tradition, to honestly consider and debate and judge whether the president's nominee is a person who is qualified to be on the Supreme Court.
So do you all agree that the Republicans, if they don't change their position, would be violating the Constitution? Because I have another follow-up question after that.
I do, Senator. That was essentially the argument of
Yes.
my earlier remarks.
So what is the remedy when a body violates the Constitution?
Guantanamo.
No, really, this is a serious question.
know,
I mean,
sorry.
really, what can we do? Can a whole body be impeached? Can the leader of the body be impeached? What is the remedy?
I think our remedy in the United States is, in that particular situation, is you face your voters.
And let me just add that
That's a strange remedy for a violation of the Constitution.
Well, in this context, the question is, to go another step with it, there are things that we think violate the Constitution that you can't take to court. Geoff's former colleague, Cass Sunstein, wrote a terrific book about the Second Bill of Rights based on President Roosevelt's last inaugural address in 1944. And the whole book is about things of constitutional stature, if you will, that are not enforceable in any way. So sometimes now, there are ways in which, as you know better than I, exactly what the body has the power to do to eject a member. And there has been litigation, Powell against McCormick, on that. But that's a different kind of violation. So the point is, and I think it's the point of our conversation here today, which is to say to the American people that what's going on here in all the respects, the lack of historical precedent, all the rest of it, but on top of that, it's a question for the public to understand that they have a constitutional duty which they're violating.
Yes. So do you all agree that there is no constitutional remedy?
I think from the standpoint
what
of
we're
courts,
There's no judicial remedy.
There's
there's no judicial remedy.
There's no judicial remedy.
This
There's
would
a
be regarded
political
as a political.
But it's important to say that the fact that someone has the raw political power to do something doesn't mean it's consistent with their duty, right? So if we draw an analogy, let's say the House were to be working on an appropriations bill, and the Senate were to say, no matter the content of the bill, no matter what it appropriates money to or doesn't, we will not consider the bill whatsoever. It doesn't matter what it says, right? We wouldn't say, oh, they've made a decision to appropriate at zero, right? We would say they're not doing their job, and they're not fulfilling their constitutional responsibilities. So that's the analogy I would draw, and I think it's on all fours.
Or we can maybe think of a different analogy, since that's our job. So say you create a court of 9 seats, and there's a vacant seat, and the president chooses not to make a nomination. What's the remedy then? Would you say that, look, your job is to enforce the law. You're in charge of administering the laws, among many other things. You need to make a nomination. He said, no, I prefer to have a court with 8 justices. I think that would be quite problematic. And I think I can imagine a Senate saying, for that matter, even a House saying, no, we think you might have just violated your oath because you're supposed to be enforcing the entire Constitution, and that means following the law here and nominating somebody.
We have sought to impeach people for less than.
Well, yes, exactly. That's the difference between the legislative branch and the president. It gets into a long conversation about what constitutes high crimes and misdemeanors. But at least there's a remedy there, which is you could impeach, try to impeach, et cetera.
And by the way, there is a law that says that there should be 9 members of the Supreme Court, right? So that's a federal law that's being potentially violated right now. So,
Thank you.
Thank you, Senator Merkley.
Well, I appreciate so much you all sharing your expertise. I believe, Professor Greene, it was in your written testimony, I'm not sure if you gave it orally or not, that the Supreme Court is a major innovation of our Constitution as compared to what went before it. And in that regard, it was specifically established so that it would be independent of Congress. Congress could not, if you will, change the law and put it out of action. In that context, then, it certainly wasn't anticipated that Congress would be able to use advice and consent power to put the Supreme Court out of action. I've gone back and read the Hamilton's 76th Federalist paper on this topic, but is there any sense at all that anyone envisioned that Congress would use it, the Senate would use its advice and consent power to, if you will, undermine the ability of the court to function?
I think the short answer to that question is probably no, but let me just, again, underscore the fact that what we're looking at here is unprecedented. Even in the worst of times, the Senate, when it has been sort of oppositional, gives people a hearing, actually tries to consider the nomination. But this is even just the refusal to consider anything. So it's the very extremity of this refusal which distinguishes it.
I'd add advising consent at the time the Constitution was drafted wasn't clear exactly what that meant, what were the relevant criteria. Part of what I addressed in my statement is the fact that we have, over time, developed a very clear and unanimously applied understanding of what that means. That is, every single nominee who is understood to be qualified and is perceived as being relatively moderate has been confirmed, period. No exceptions. And so what the Senate has basically done is say, you nominate someone who's unqualified, we will not confirm them. If you nominate someone who's kind of off the charts ideologically, we might not confirm them. But if you nominate someone who is reasonably moderate and is qualified, we will, period, confirm. That's become the meaning of advice and consent, and it's a good meaning.
Well, and certainly Hamilton referred to the standard of unfit character. Right. And that is, it made sense to invest the power, because there was a debate as to whether invest the appointment power in the executive or in the assembly, as it was referred to. And the conversation was, well, it made a lot more sense to give it to a single person because there's more accountability and more judgment and less deals to be struck. However, should that individual go off track and start appointing people who were friends and families and favored individuals or people who were inappropriate because they didn't have the experience, well, then the Senate would serve as a check on that. So that's the standard that at least was discussed then, of an unfit character. And I don't see any kind of foundation, if you will, for us to exercise advice and consent other than in that context of an egregious nomination where someone, individual, either is unfit by experience or by character. And is there any other standard by which the Senate could reasonably say it's exercising its responsibilities?
I think that captures it quite well. Although people who are extreme ideologically, who may be qualified in some technical sense, also fit within that description. But with that caveat, I would say that's exactly what the United States Senate has done for 225 years. And that they figured out that makes sense. That's the best approach to working out the balance between the President and the Senate, which is there to serve as a check for irresponsible nominations.
And just to say, Senator, the obvious in our conversation, that does not include refusing to even consider the nomination.
I think the key word here that you used is individual, right? Where the Senate's role is to evaluate particular nominees, not to prevent the process from happening at all. And you won't see anything in the framers or in the Federalist suggesting the Senate can prevent the process from happening.
Is not the balance of, well, I see I'm over my time here, so.
We don't have
my
quite
colleagues.
the strict rules. If you want to ask one more question, and then we'll go over to Senator Casey.
Well, thank you for that courtesy, Madam Chair, and specifically, we have a Constitution crafted with this balance of powers between three branches. But if the Senate uses its advice and consent responsibility to either undermine the executive by refusing to fill key positions, or undermine the courts by refusing to hold a conversation and vote on court nominees, isn't the Senate deeply abusing its advice and consent power, which was never designed to create an imbalance of powers, if you will, in which the congressional branch has the power to systematically undermine the other two?
I said in my statement, Senator, that we've had 8 years of two-way failure of separation of powers. And this is the first time in history, as well as the first time by this group of people, to have a three-way destruction of separation of powers.
I might also just sort of add one additional point, which is it probably is not that hard to imagine moments in the past when the Senate has perhaps abused its power. But the critical thing is that's no reason to follow it. If that actually did happen, if there were those abuses in the past, that would make the weakest possible precedent ever to follow. There's every reason not to follow it. But the point is, here, the tradition is actually to give a hearing, not to simply decide you're going to take a holiday and not do anything.
Thank you.
Very good. Thank you. Senator Casey, last but not least.
Madam Chair, thank you very much and appreciate you calling this hearing. It's a distinguished panel and we're grateful for your testimony, the presentation of which I missed, and my question or two might elicit a response that's already in your testimony. So if you're responding by way of reiteration, I apologize for that, but around here it does help to repeat ourselves. so you can help us do that. I'm particularly stunned by this position that Republican senators have taken. This is my 10th year in the Senate. I thought I had seen it all until this. It's a stunning dereliction of duty. I don't know how else to say it. And if it's not, the tyranny of ideology, it's the tyranny of raw politics. I'm not, depending on what day it is, I'm not sure they're doing it purely for ideological reasons or purely for political reasons, or both. But it's tyrannical, and it's misguided, and bad for the country. And it seems like the same thinking that resulted in a government shutdown back in 2013, when most people thought we'd come to the precipice and not fall into the abyss, and we did, because you had one party in the grip of an extreme group who said, let's shut the government down. That's what happened. This may not be a shutdown of the Supreme Court, but it's certainly a partial shutdown, or at least it's at least something that inhibits the court from doing what it must. I guess one thing that I'm hung up on is this, and you may have already addressed this both in questions in your testimony, but the impact of 4 to 4. And what effect do you think that has on jurisprudence, setting aside the obvious effect it has on confidence and in measurements like that, or assessments like that, but just on jurisprudence or functioning of the court? How do you assess that? I offered for the panel, and maybe Peter, we could start with you and go right to left.
Well, Senator, we did talk about that some. We expect, although there are periods of time when there's a vacancy and the court functions 4 to 4, or somebody decides not to participate in the decision process, but especially for the amount of time that's here, it really it just warps the process, and it leaves us, if you're looking at it from a liberal and conservative scorecard, it depends what the lower court did, and so we could name some that are on the docket right now, where from a liberal point of view, it's going to leave in place a lower court thing, and we say, wow, we might have lost that. That's not a good way to do business, but that's what it is. And Professor Greene made clear, which is, we know as lawyers, which is that sometimes, because it's partly the business of the court, very heavily the business of the court, to resolve differences between circuits. Well, those are left in place, and you have different law in different parts of the country. So it's a very big point.
Anybody else?
Sure. We're potentially talking about 2 full terms of the court in which it's unable to decide the closely contested, what would have been 5 to 4 decisions and become 4 to 4 decisions. And as Professor Edelman said, that leaves in place divisions of authority within the lower courts, which it's the job of the Supreme Court to resolve. The Supreme Court has multiple responsibilities, but one of its main core functions is to resolve those disagreements, and it leaves the law in a state of uncertainty.
So the choice here is to deliberately choose to leave the court in this circumstance. It's a different circumstance if, for example, there were a nominee and there was some thought considered and there was a rejection, not quite the same calculation there, but there's a deliberate choice to leave the court understaffed in this circumstance. So there's a cost to certainty, there's a cost to the court, and now the question becomes, what's the benefit? There's no grand principle at stake here. There's no benefit other than a partisan one.
I think the dysfunction that would be created in the next year or two in the court is to be taken very seriously. But my own view is that the stakes here are actually much higher than that. The stakes here are the fact that we have had and developed a tradition about the confirmation process for Supreme Court nominees, which has actually been quite consistent and has worked quite well. And this throws that into chaos. And that the long-term implications of this, I think, are extremely dangerous and severe. And I think that frankly, members of the Senate should think about this in those terms. When the South seceded, Lincoln didn't say, oh, let him go. Right? I think this is like that. I think this is a moment when it's really important to stand up and say these stakes are extraordinarily high. They go to the rule of law of our Constitution and of our government.
I guess there's a part of us that believes that even when the legislative branch goes in a direction that a lot of people don't want it to, that somehow this branch of government would be walled off or immune from that. And it's not the branch that's doing it; it's the legislative branch not doing its job. I guess the other question I had on the kind of the deadlock question is emergency matters that come before the court. I don't know if you've already spoken about that, but if anyone can assess that.
Well, it's the same point. You're lacking a vote, and if you need 5 votes, and the way it confers there, that's 4-4, then there's something that's really, really, really needs to be done right then, decided. You can't. So yes, just a key point.
It may just be worth reiterating the fact that there's no exception to the Senate's duty here.
Right.
There's no opportunity for it to sort of take time off. If, God forbid, there were a war or something like that, we would expect our leaders to sort of be on call. And that's not a time to sort of say, well, we're going to choose not to defend this country. That's not a choice. That's a duty. And the same thing happens here, I think. There's not a choice to abandon your job. Or if you make that choice to abandon your job, then somebody else should fill your slot.
Well said. Thank you,
All
Madam
right.
Chair.
Well, thank you very much. And I neglected to go through all of your credentials. We still have a lot of some reporters here and people I know that are watching on the live stream and on C-SPAN. And I didn't do it at the beginning because we had so many senators here and I wanted to get to that. But to be fair to all of you, and so our listeners and people that are here watching understand, these are some experts on the court like no other. We have Professor Stone, who was Dean of the Chicago Law School. He was law clerk to Supreme Court Justice William Brennan, and in recent years he has served as the chair of the board of American Constitution Society. We have Peter Edelman, who was also law clerk to Supreme Court Justice Arthur Goldberg. He's been on the faculty at Georgetown. He was also counselor to HHS Secretary Scalia, legislative assistant to Senator Robert F. Kennedy. Can't get better than that. Michael Gerhardt, who's with us from North Carolina, a distinguished professor of constitutional law, served as special counsel, assisting the White House on Justice Stephen Breyer's confirmation hearing. In 2005, he advised several senators on President Bush's nomination of John Roberts as Chief Justice. He testified as an expert witness in the confirmation hearings for Justice Samuel Alito. He serves as special counsel to Chairman Patrick Leahy and the Senate Judiciary Committee for the nominations of Sonia Sotomayor and Elena Kagan. And finally, Jamal Greene, and we're so pleased he could join us. In addition to being the Vice Dean for Intellectual Life at Columbia, he teaches and writes in the areas of U.S. constitutional law and theory, and the federal courts, comparative constitutional law. From 2007 to 2008, he served as the Alexander Fellow at New York University School of Law. He was a law clerk to Justice Paul Stevens on the Supreme Court. He received his AB in economics from Harvard. He earned his JD from Yale Law School in 2005 where he served as the article's editor. So these are some pretty heavy-duty professors. And I've also heard from more conservative-leaning professors who believe the same thing, that the Constitution is the Constitution, that shall means shall, that people have a duty to do their jobs. And I'm sure, like all of us, our colleagues were shocked when Justice Scalia died. That happened. But when things happen, you have your jobs to do. You have your jobs to do. And that is really what this is about today. It's about a constitutional duty, a solemn oath that people take to do their jobs, and respecting not only the history of this country, but really the basic constitution on which our country is based and our government is based. So I want to thank you for taking the time to join us. There were some comments made about the need from Professor Stone to continue standing up. You have seen the Democrats in the Senate be very clear, from our most liberal senator to our most conservative Democrat, that we believe that the Constitution is clear and there's a duty here. On the Republican side, you have heard a few senators say that they think that we should have hearings, that is part of our duty for advice and consent since 1916, as you pointed out. And before that, the Senate still advised and consented in its own way. But no one refused to meet with nominees or said that we wouldn't move forward with the process. We move forward with the process. So I want to thank you so much. We don't think this is going to end. We're going to continue this. We have gotten millions of petitions and emails from people all over the country that say they want to move forward with this, and the American people won't be silenced. So thank you very much.